When does police surveillance cross the line into an illegal search? The Fourth Amendment protects against unreasonable government searches and seizures. A search occurs when government action violates a person's reasonable expectation of privacy. This standard was established by the Supreme Court in Katz versus United States. The Katz test requires a two-part inquiry. The individual must first exhibit an actual subjective expectation of privacy. Second, society must be prepared to recognize that expectation as reasonable. The objective prong is the central focus of Fourth Amendment analysis. If the government action does not violate a reasonable expectation of privacy, no search has occurred. The Fourth Amendment is not implicated without a search. This framework defines the limits of government intrusion. The subjective prong is usually easily met by the defendant. The individual must take affirmative steps to conceal the item or activity. This includes closing window blinds or locking a storage container. The objective prong determines if society deems the expectation legitimate. There is a high expectation of privacy within the confines of a private home. Expectations of privacy are significantly diminished in public places. This includes streets, vehicles, or commercial establishments. What a person knowingly exposes to the public is not subject to Fourth Amendment protection. This applies even if the exposure occurs inside their home or office. Government observing something visible in plain view does not constitute a search. The third-party doctrine dictates that a person has no reasonable expectation of privacy. This applies to information voluntarily conveyed to a third party. This rule is based on the assumption of risk principle. The individual assumes the third party might reveal the information to the government. Bank records provided to a financial institution are unprotected under this doctrine. This was established in United States versus Miller. Telephone numbers dialed and recorded by the phone company are also unprotected. This rule comes from Smith versus Maryland. The government obtaining this information directly from the third party is not considered a search. This is true even if the individual is unaware of the transfer. The government action does not violate the Katz test. This doctrine significantly limits privacy expectations regarding transactional data. The Fourth Amendment protects houses, which includes the area known as curtilage. Curtilage is the area immediately surrounding and associated with the home. Curtilage is treated as part of the home itself for Fourth Amendment purposes. Factors determining curtilage include the area's proximity to the residence. Courts also examine whether the area is enclosed by a fence. The nature of the uses to which the area is put is another factor. Steps taken by the resident to protect the area from observation are also considered. Conversely, open fields are entirely unprotected by the Fourth Amendment. This is true even if the fields are fenced or posted with no trespassing signs. This rule was established in Oliver versus United States. Government intrusion into open fields does not constitute a search. There is no societal expectation of privacy in these large, undeveloped areas. The public nature of the land defeats the Katz objective prong analysis. The use of technology to enhance natural senses during public observation is generally permissible. For example, using binoculars to observe activities visible from public airspace is allowed. Observation from a public street using standard tools is also permissible. However, technology that reveals details about the interior of a home is a search. This applies if the details could not otherwise be known without physical intrusion. Kylo versus United States established this critical boundary. Kylo held that using a thermal imaging device is a search. This device detected heat emanating from a private residence. This technology revealed information regarding the home's interior. This information was not available to the public without physical entry. This protects the sanctity of the home. A search also occurs if the government commits a physical intrusion upon a constitutionally protected area. This is separate from the Katz reasonable expectation of privacy test. This is the common law trespassery test. It was revived by the Supreme Court in United States versus Jones. Jones held that attaching a GPS tracking device to a suspect's vehicle is a search. Using the device to monitor the vehicle's movements constitutes the search. The vehicle is in effect protected by the Fourth Amendment. The physical occupation of private property is required. This occupation must be for the purpose of gathering information. This physical intrusion is sufficient to establish a search. This is true regardless of any expectation of privacy in the vehicle's public movements. The trespass test provides an independent path to finding a Fourth Amendment search. The Supreme Court modified the third-party doctrine in Carpenter versus United States. This ruling applies specifically to highly sensitive aggregated data. The court held that the government's acquisition of 7 or more days of cell site location information constitutes a search. CSLI provides a comprehensive, intimate record of a person's movements and associations. This record exceeds the limited information assumed to be risked under the traditional doctrine. While the data is held by a third-party carrier, the depth and duration are critical. CSLI implicates a reasonable expectation of privacy in the whole of one's physical movements. Warrantless access to this data violates the Fourth Amendment. Carpenter recognized that technology requires new limits on government surveillance. This ruling protects citizens from extensive digital tracking. A Fourth Amendment search is established through 2 complementary paths. First, the government's action violates a person's reasonable expectation of privacy. This is the standard set by the Katz test. Second, the government physically intrudes upon a constitutionally protected area. Protected areas include persons, houses, papers, or effects. This physical intrusion must be for the purpose of obtaining information. This is the standard established by the Jones Trespass test. Both tests must be considered when analyzing whether a search has occurred. If either test is satisfied, the government action is legally defined as a search. A search requires a warrant or an applicable exception to the warrant requirement. The search must be deemed reasonable under the Fourth Amendment. Failure to meet this standard results in exclusion of evidence.